Fine to press the microphone button until the light turns from red to green. Say your name. If you're new to this, please spell your name for the record. Please speak clearly and speak up so the committee, those in the room and those listening online can hear and understand you. Then add the agency organization that you represent. If you are here as a private citizen representing yourself, please tell us where in this great state you reside. Remember that all dialogue must be directed to the chair, and witnesses are expected to remain polite and civil during their testimony. Audience members online wishing to testify should raise their virtual hand at this time so we know that they're out there. Those registering will be emailed a link to participate in the Zoom platform. Again, if you're not wishing to testify, please just watch on the YouTube link. For those online, at the time that I call for public testimony on a topic that you wish to testify, please raise your virtual hand and you will be called upon as time allows. Staff will then modify the attendees' credentials, at which point they will need to have their video turned on and their microphone unmuted. Public testimony will probably last no longer than 3 minutes unless an extension is granted by the chair. Do we have any virtual attendees so far today? Okay. The bill or bills being discussed are located on the meeting calendar page on the legislative website. We will now begin with House Bill 10. House Bill 10. Mr. Short, would you like to come up to the table, please? We have a roll call.
Representative Crago.
Here.
Representative Chestick.
Here.
Representative Harrelson.
Here.
Representative Jennings. Representative Nemec.
Here.
Representative Oakley.
Here.
Representative Provenza.
Here.
Representative Rodriguez Williams.
Excused.
And Chairman Washut.
Here.
Thank you.
Okay, so Mr. Short, House Bill 10 is an interim bill that was worked by the House Judiciary Committee. We have a few new members who were not with us during the interim. Would you mind just kind of laying some groundwork of what this bill accomplishes and why it was brought to Judiciary?
Well, thank you, Mr. Chairman, members of the committee. This bill addresses.
Would you state your name and agency?
Terribly sorry, Mr. Chairman. I'm Robert Short. I am a county commissioner in Converse and currently serve as the treasurer for the Wyoming County Commissioners Association. And it's with great pleasure that I'm actually able to be here, as the sledding getting here was quite an enjoyable trip. Thank you very much for the work that you're doing addressing this bill. The bond amounts set by the legislature 1800s have not been adjusted since. And maybe there's been a few changes in the amounts of money that have been allocated and utilized, as well as been handled by different organizations throughout that time. We think it's important that this is addressed. However, we do have some concerns about the amounts that are currently being proposed, as we think perhaps a blanket amount across all elected officials may not necessarily be required. For instance, we think that there are certain individuals inside of organizations who actually have no ability to touch money directly. And so those individuals being bonded at that amount may be an unnecessary tax expenditure that does not give us any kind of additional benefit. So we think that, for example, coroners really don't see any kind of influx or outflow of cash. So we think that perhaps maybe a $5,000 amount would be adequate for coroners. We feel similarly towards county commissioners. County commissioners, again, have no authority to touch capital, to touch cash in or out. So we think a $5,000 amount would be adequate. If that amount were $10,000, I don't expect there'd be a substantial pushback from any of our county commissioners. We believe that other officials inside the counties, obviously clerks, assessors, tax, and the sheriff, as well as the clerk of the district court, all see capital, actual cash dollars flow across their counters. And an adequate amount is necessary to ensure that the public is protected.
Thank you. Are you familiar with so I recall from the interim, there was at least one incident in the state where there was a question about the bond. Could you kind of illuminate that a little bit?
I'm not privy to the exact amounts, but yes, there was some monies that were absconded with during this time. And I don't remember the exact amount, Mr. Chairman, but obviously there's been more than one incident that this has been a problem in recent years. And I think that it does need to be addressed in a way that's protecting the taxpayer, protecting the people inside of our great state.
Thank you. Any questions for Mr. Short? Representative Craigle?
Thank you, Mr. Chairman. Commissioner Short, just a quick question. And do you know the difference in cost to the counties for $5,000 bond versus $100,000 bond? What kind of additional, I mean, it's really insurance at the end of the day, but what's the additional cost of that bond?
Mr. Short, if you know.
Mr. Chairman, Representative Craigo, I don't know the exacts. I know that statewide, we're talking about a little bit north of $30,000. So I don't know the exact between 5,000 and 100,000. I'm sorry, I haven't actually researched the exact amounts.
Thank you. Just to clarify, that's $30,000 for all the counties to buy the increased cost. Okay.
Yes, Mr. Chairman.
Follow up.
Thank you, Mr. Chairman. Commissioner Short, could you go back and explain the 30,000? Is that per county or statewide?
Mr. Short.
Mr. Chairman, Representative Craigo, that is a statewide number to the best of our current estimation.
Thank you. Any other questions for Commissioner Short? Seeing a bunch of hands, stay close. I have some follow-up questions for you. Okay.
Thank you, Mr. Chairman.
Committee, since this is a judiciary bill, let's just kind of walk through it real quickly and then we'll take some more testimony. On page 1 of the bill, you see the intent of the bill to deal with our bond amounts. And at the bottom, we get into the crux of the bill on lines 14 through 16, setting the bond amount that was previously $10,000 and raising it to $100,000. And on page 2, we deleted the language about 2 or more sufficient sureties. That's kind of antiquated language, had been left around since probably territorial days. And so we've stricken that. And then on 74101 in the middle of the page, we set the bond amount for the coroner at $100,000 with a sufficient surety. Then on the bottom, we switched to county officers and all county officers on page 3, line 1, all county officers except county attorneys shall post within 20 days their bonds. In the middle of the page, county assessor is addressed, a bond approved by the Board of County Commissioners of being increased from $5,000 to $100,000 and sufficient surety. Then on the bottom of the page, line 18, we address county clerks and again set that bond at $100,000. And on page 4, county commissioners also set it $100,000. The sheriff set it $100,000. The county surveyor set it $100,000. And that's what we're doing with this bill. The historical case that was referenced, we had a county where there was a theft by one of the county officers, and the bond was insufficient to cover the extent of the loss. So that's what prompted this bill to come before us. Okay. Anybody else wishing to testify on this bill, please come forward. You look familiar, but I'm blank on the name, so you're going to have to help us out.
Mr. Chairman and committee, my name is Mary Langford, and I have the honor to represent the County Clerks Association. I am a retired county clerk out of Sublette County, and we really appreciate the fact that you have looked at the amounts, especially the old 1800s law. The whole time that I was in office, I was required to have a $4,000 bond. And when I left office, I was handling to over $200 million in my budget. So $4,000 was quite not going to cover any of that if I decided to go somewhere else with the money. So we appreciate you looking at that. One of our concerns was with the development of this bill is the requirement for 2 sureties, and you've reduced that to 1. It's almost impossible to get 2 sureties. You're buying 2 insurance policies. So it's a waste of money, basically. We also probably don't have a really good idea or suggestion for what the magic bond amount number should be. Agree with our commissioner here that there are certain folks that handle money in the county and there are certain folks that don't. And probably the folks that are at counters taking fees and collecting taxes and those types of things should be bonded sufficiently. Folks that build budgets and spend the county's money should be bonded sufficiently. Commissioners, they probably need a position bond, but they don't need to be bonded for lots of money. And possibly in relation to that, I think this is a great place to start. I imagine we'll probably work on it and refine it as time goes on. But thank you for considering this. Bonds have always been a mystery. And I think that there may be something to look at as far as bonding and insuring as well. So, but that's basically all from my association. We support this work and I'd be happy to stand for any questions.
Questions for Ms. Langford? Representative Jennings?
Thank you, Mr. Chairman. Ms. Langford, thanks for being here this morning. So other than theft, what else, do you sometimes misplace $100,000? Just, what is, other than theft, other than a criminal activity, what would this cover?
Ms. Langford?
Mr. Chairman, Representative, I think that's exactly the only thing that it could cover would be theft. The other, I am a little bit familiar with the case that probably brought this. There have been cases in the past over the years around the state, and it's theft of money.
Representative Kriegel?
Thank you, Mr. Chairman. Ms. Langford, wouldn't the bond also cover negligence? If you accidentally, for example, as clerk sent out a check for twice as much as you were supposed to, or even 100,000 more than you were supposed to, it would cover that circumstance as well, correct?
Ms. Langford?
Mr. Chairman, Representative, yeah, errors and omissions, and usually your insurance policy covers errors and omissions. But your bonding, I believe, has some coverage there as well. So for mistakes.
Follow up, Representative Kriegel?
Thank you, Mr. Chairman. So going back to these bond amounts, just a question on, do you think, for example, I understand some of them maybe need to be lowered, but you just explained that you were handling several hundred million when you left the office. Is 100,000 sufficient? Do we need to think about raising some of these beyond? And just to go back a little bit historically, when we worked this in the interim, originally we were just talking about district court clerks. And I think some of us thought we were narrowing the focus too much, that really we needed to look at all of these. And so really at our last meeting, we sort of just said, okay, we're going to pick a number and set it across the board, knowing that we would probably have this discussion when we got to session. So the question for you is, in the county clerk position or any of the others, is that enough? I mean, do we need to think about possibly raising that one while at the same time lowering some of the others?
Ms. Langford?
Mr. Chairman, Representative, I think that would be something that would be really be helpful. I tend to agree with Commissioner Short that a blanket number or blanket plan across the state, across the offices, is probably not the best plan. It could be better, be done better as well.
Thank you. Any further questions? Representative Chesnick?
Yeah, so I, I kind of agree that bonds are intended to cover theft, and errors and omissions policies covers negligence, other kinds of things. I understand that. But there is some language in the bill that I'm confused by. And that is on under amount of bond and conditions on page 2, line 3, the bond is conditioned upon, there's a list of things, but they're conjunctive, and so all three of them all three things must be covered. But on line 3, it says conditioned upon the faithful performance of the duties of his office. Faithful performance of the duty of his office could be something other than theft, I think. And I'm not sure what that's intended to cover. Do you have any understanding of or thoughts about what that condition might be?
Ms. Langford?
Mr. Chairman, Representative, I know it's not fair for me to ask a question back, but my comment is I don't know how you would determine faithful performance and be able to penalize that or I think that falls more under like maybe the errors and omission portion, and I don't know. But yeah,
Okay.
that's a tough
That's a
one.
fair answer. Yeah, that's a fair answer. And that is existing language in the statute.
I understand that. I'm just confused by it. And I know I tend to be looking beyond what you're trying to do here sometimes, but as long as we're in the bill, I don't know how to fix it or if there's a fix needed. I'm just trying to get information, really. Thank you.
Thank you. Further questions from Ms. Langford? Representative Harrelson.
Thank you, Mr. Chairman, Ms. Langford. So just for my clarification, and what we were looking at is obviously the position of county assessor, obviously large amounts of money could potentially go across that desk. Clerks, large amounts of money could go across that desk. The commissioners, not as much, correct? And then also into the realm of the, it would be the coroner. So it's the coroner, the commissioner, and then the final one being the surveyor. Those are the three that are kind of in question as probably not being as important. And would a 10,000 number look more palatable? Is that still an overshot? What's your thoughts?
Ms. Langford.
Mr. Chairman, Representative Harrelson, I think a 10,000 number is a good place to start. I think about what a county surveyor does. I know in our county, my experience was he had $1,000 bond, but he didn't handle money. He did work that probably was more an errors and omission kind of coverage in that case, as opposed to handling money. The assessor, she or he determines a lot of tax value and those types of things, but is actually handling money over the counter. They don't handle money. But treasurer, absolutely. The clerk of court, the sheriff,
Yep.
Those folks, they are taking fees. They're distributing money in the course of their work. So
Ms. Langford, if I'm clear, in addition to the bond, the county also carries an errors and omissions insurance policy separate from the bond. Is that correct?
yes, Mr. Chairman.
Okay. Follow up, Representative Harrelson.
Yes, thank you very much, Mr. Chairman, Ms. Langford. So the other question I have is, I mean, and I know we've kind of shot around it, but we don't have any definite numbers. 100,000 in this day and age doesn't cover everything. We know that. Do we have some? I mean, I think in some ways I feel a little in the dark. What's the cost for the county for going to a $500,000 bond or something of that nature? Is this a huge offset? Is this a situation where it's going to add a couple $1,000s to the budget every year for the protection that it brings? So I think we need to kind of have maybe some some vision into what that is so we could properly set these numbers. And if not that, are you okay with staying at 100,000 on those other positions?
Ms. Langford.
Mr. Chairman, Representative, I agree with you. I don't know what the magic number is. And I know that when you buy those bonds, you pay by the thousand. It's an amount, and it's also a commercial situation. You might be able to get a cheaper one from this agent as opposed to that agent. It isn't going to be a standard cost across the board. So it's really hard to quantify what that number is going to be. But I think we need a starting place.
Yeah.
And that's that magic number.
Thank you. Any further questions from Ms. Langford? Anyone else in the room wishing to testify on House Bill 10? Seeing none, committee, what is your preference? Oh, we have somebody on Zoom? What? None? Okay. Okay, committee, your preference? Move the bill by Representative Craigo, second by Chesnick. Do we have any proposed amendments to the bill?
I do.
Representative Harrelson.
So the first change would be on line page. It would be page 2, line 15, where we would strike $100,000 with the numeric $100,000 and replace that with $10,000 and the numeric $10,000. The second correction or change would be found on page 4. And it would be line 3, where we would strike $100,000, replacing it with $10,000. And subsequently also page 4, line 11 and 12, where we would remove $100,000 and replace it with $10,000. So from what I saw, it would be 3 corrections or 3 additions in this amendment. Is that clear to you guys? Okay.
So.
Second
Representative
one.
Harrelson, will you repeat that one more time for?
Yep. So the first one would be page 2, line 15, which covers our coroners. And that would be 100,000 to 10,000. Then it would be page 4, line 3, which would be our commissioners, removing the 100,000, replacing it with 10,000. And then the third correction would be, or change would be page 4 on line 11 and 12. And this is for the surveyor to go from 100,000 to a 10,000.
Okay, the amendment has been moved by Representative Harrelson, seconded by Representative Provenza. Discussion on the amendment.
Yeah,
Representative Jennings.
Mr. Chairman, so I'm okay with these amendments except for the one on 2. And since these are going to be taking care of mistakes, I mean, we don't think about a lot of money passing for coroners, but maybe going through pockets or jewelry, they find an extra 100,000. So I would I'd be against that on page 2, but the rest of them I'd be all right with.
Are you wishing to divide the amendment? So Representative Jennings moving to divide the amendment. Do we have a second on the division?
I'll second that.
Okay, so is it friendly? Do you want to
It's
just
friendly.
strike the coroner for this discussion?
Yeah, if we could just remove,
All right,
I'd
so
be okay as a friendly amendment to remove page 2, line 15 from my amendment.
Debbie, are we clear that we're now only talking about the commissioners and the surveyor being reduced to $10,000? Everybody clear on the amendment? Representative Provenza.
Thank you, Mr. Chairman. I hesitate on that only because I wonder if our local government liability pool statutes cover that sort of, I guess if it's theft, without seeing our liability, our local government liability pool statutes in front of us, I would just say this committee, we should find this out before we go to the floor for sure. Because I appreciate the the thought of the amendment. We don't want to have our tails out in the wind or anything. But also knowing that that's not in this portion of this bill. So, and I need to look it up. Thank you.
Representative Craigo, do you know the answer to that by chance?
Mr. Chairman, I don't know the exact answer to that offhand. I believe it does not, which is why they ended up in the situation that they did in Platte County a few years ago, is that usually liability insurance as a general rule does not cover intentional acts, including theft. But I don't know that. I'm just winging it there.
Mr. Chairman,
Representative Jennings?
along those lines, maybe we could ask the commissioner, I mean, because that Representative Provenza brings up a good point. I would have always been under the impression that county commissioners carried insurance plus the state. And so the state might not apply in that, but counties might have carried bond anyway. Do they not?
Representative Craigo?
Thank you, Mr. Chairman. The difference is by doing this, we're saying they have to. There's no requirement that they have to participate in the pool or have to purchase separate insurance. I think all of them do, but most of them do probably. But this is really us saying you have to, in this, I mean, bonds are essentially another type of insurance. And so we're saying, hey, you at least have to pack this much coverage to protect the public, to cover your official, your actions in official office. But I think most of them have an insurance on top of that.
Thank you, Representative Jennings. Did I answer your question?
Yeah, if that being the case, and clearly this hasn't been updated since 18, whatever, a while back. It seems like that they're probably already doing this. Is there a case where they've not, where somebody has misplaced?
Mr. Short,
A
if you
couple
just nod your head, if you
$100,000?
think you can answer this question. If not, I'm not going to reopen public hearing. I think the question is whether the errors and omissions insurance would cover a deliberate theft. Representative Craigo?
I know it did not in the case of Platte County. I mean, that was or Goshen County, excuse me. I keep saying Platte, Goshen County, because that was why this came to us. There was essentially the county was out the money, and it's complicated by the fact that it was, I mean, some of it was actually, I think, the state's money because of how court filing fees come in. It goes into an account, and then at the end of the month, you do an accounting and you send some money to the state. So the county was on the hook for county money and state money. And they had to reimburse it. And my understanding from testimony during interim was that did not get covered because it was an intentional act. Whereas bonds, during this, I actually went home to the county and asked my clerk, I need to read the bonds because I hadn't read them in a while and I couldn't remember what they actually said. And they do cover criminal acts, theft, etc. I mean, that's the difference between these probably and normal insurance.
So, Mr. Chairman,
Representative Jennings?
so was to Representative Craigo, so were they carrying what was legally required? I mean, did we get the whole $4,000 back or?
Representative Craigo, if you know.
I actually don't know, Mr. Chairman. Representative Jennings, I don't remember if that was actually testified to during interim, to be honest.
Okay, further discussion on the friendly adjusted amendment to lower the bond to $10,000 for the county commissioners and the surveyor. No further. All those in favor of lowering the bond amount for surveyor and commissioner to $10,000, say aye.
Aye.
Those opposed, no. So that amendment has carried. Debbie, are we good on that? Okay. Any further amendments? Okay, let's make sure we have no more amendments and then we'll, all right. Further discussion on the bill. Representative Chesney.
Yes, when I was looking through this, I was wondering why the treasurer isn't covered in this. So I looked up the bill or the statute and it's covered in section 7, Romanet 7, which is not being amended. So Romanet 7 will stay the same. And it says a bond in an amount prescribed by the Board of Commissioners, which I think is fine. But it also says with an approved corporate surety company or at least 3 sufficient sureties. So do we need to think of, we're changing at least 2 down to 1 in the other, in all these others. We need to worry about the language in Romanet 7 that's not being amended. Should that be added to the bill?
That sounds like a fair question. Let me just read through the bill title here real quick. Representative Craigle.
Thank you, Mr. Chairman, Representative Chestick. We worked this topic extensively through the interim, and that was one of the things we talked about. We actually discussed the treasurers. The county officials asked us to leave that one alone because it works sufficiently. The way that one works, and some counties, it depends on the county's valuation and how much money the treasurer is handling on a day-to-day basis. I think one county has their treasurer bonded at 200 million. One county, some of the poorer counties have their treasurer bonded at, $1 million. It just depends on what their actual amount is. And so that language, they asked us to leave it alone because it works the way they want it to.
Representative Craigo, I recall that, but I think the Representative Chestick's question is regarding the 3 surety requirement. Is that correct? Representative Chestnut.
Mr. Chairman, thank you. I guess it may be okay the way it is. The language of Romanet 7 is filed in the Office of County Clerk with so there's an or in here. So I think the or probably saves it. With an approved corporate surety company or at least 3 sufficient sureties. So if you have a AAA bonded or a good insurance company, a corporate surety company, I guess that would be 1 insurance company. So I guess that probably saves it. Trying to read this on the fly here.
Thank you, Representative Chestnut. I think the or is the operative word there.
Yeah, I think or saves it.
Any further discussion on the bill? Seeing none, we'll have a roll call on House Bill 10 as amended.
Representative Craigle,
Aye.
Representative Chestick,
Aye.
Representative Haroldson, Representative Jennings, Representative Nemec,
Aye.
Representative Oakley. Aye. Representative Provenza,
Aye.
Representative Rodriguez Williams,
She left an absentee vote, voting aye.
and Chairman Washut.
Aye.
We have a total of 9 ayes and 0 noes.
So House Bill 10 has passed House Judiciary Committee. We take us now to House Bill 15. House Bill 15 is another county-related bill, and it's one that we worked during the interim. A fairly straightforward bill. If you read through it, you'll see that the Board of County Commissioners may dissolve any board or district created under statute. But it is my understanding of the language here that it strikes the reference which would deal with museum board. Commissioner, you want to come forward? Thank you. Want to state your name and organization one more time and then tell us a little background on this bill, please.
Thank you, Mr. Chairman. Robert Short, Commerce County Commissioner, representing the Wyoming County Commissioners Association as the treasurer. Mr. Chairman, this bill as it currently exists is fully supported by the body of the County Commissioners Association.
Thank you. And was I correct? It's a summary. Bottom line on this bill is that it establishes that county commissioners do not have the authority to dissolve archaeological, geological, historical museums under its general authority to dissolve other county created boards. Is that correct?
Mr. Chairman, to my understanding, yes, sir.
Any questions for Commissioner Short?
Yeah,
Representative Jennings?
yeah, thank you, Mr. Chairman. Why?
Commissioner Short?
Thank you, Mr. Chairman. Representative Jennings, I believe the appetite is not quite big enough to bite off a full museum in one bite.
Representative Jennings?
Thank you, Mr. Chairman. When I read that in the catch title and not having been here for the interim, it says to dissolve county created boards. So you want the capability to create it, but you don't want the capability to dissolve it. Why?
Commissioner Short?
Mr. Chairman, Representative Jennings, I am a little bit at a loss. I thought the language was the ability to dissolve a specific board county created. So I am completely at a loss at this moment, sir.
As I recall the testimony, we did have a bill previously that dealt with the county's authority to dissolve other types of boards. And there were, because of the artifacts and other accumulated items and the complications of just doing away with a museum board, a little different than some of the other boards. And so this one was carved out at the request of the counties that this be clear that these types of boards would not be dissolvable in the same manner. Representative Crago, do you recall any further detail on that discussion?
Thank you, Mr. Chairman. So I think those of us that were here last year remember the lively floor debate regarding this new, this is a brand new statute. Section 525 is brand new as of last year, and we spent a lot of time on the floor debating it. I think most of us remember it was pretty interesting, and we started exempting out boards during the floor process that we could or could not dissolve, and there was a lot of reasons why. Of course, this goes back to a Laramie County case, and so that's where this all started regarding fairgrounds. And then it morphed into something else. And I think the way the testimony came in over the interim was that the museum boards around the state didn't, because, as the good chairman said, because of all of the property they hold within those museums that is gifted to the county, sometimes on loan, sometimes in perpetuity, it was going to create all sorts of problems on what do you do with all that stuff if the museum board is just gone? And so that's the other one. A lot of the other boards don't suffer that same problem. And so they asked that they be removed from the statute so that the county commissioners cannot dissolve it through the process set out in 525. That was the testimony, long and the short of it, through the interim. And it was requested by the County Commissioners Association. I think they were getting a lot of concerned museum board members back home. Every single one of them is what it kind of sounded like.
Okay, anyone else wishing to testify on this bill? I saw some raised eyebrows over there. So please identify yourself and
Thank you, Mr. Chairman. Commissioner Natalie Amacker, I'm the Vice President of the Wyoming County Commissioners Association, and just wanted to add that this bill this year is essentially a cleanup. That there's no changes to what happened previously. There was just another piece that needed to be added in. So no powers are changing from the legislation that was passed previously.
so previously you did not have the authority. This just makes that clear. Is that correct? You did not have the authority to dissolve a museum board, and now we're just putting in verbiage to say you don't have authority to.
Thank you, Mr. Chairman. I believe that's correct. The amendment last year was incomplete. And so this is adding another place that needed to be cleaned up to do that. So we continue with this bill, we would continue to not have the power to dissolve.
Thank you, Cliff. Any questions from the committee? Representative Chestnut?
So a museum commission can dissolve itself? Is that the only way to dissolve a museum if it can't be involuntarily dissolved? Is that the answer?
Representative or Commissioner?
Thank you, Mr. Chairman. Representative Chestick, I do not know. I would have to look up the dissolution.
Okay.
Representative Craigle?
Thank you, Mr. Chairman. Just to answer Representative Chestick's question, I mean, if there's actually a case on this, that's what started this whole momentum. And it's a Laramie County case, and it's Laramie County versus the Laramie County Fairgrounds, I think, something along those lines. It's a Supreme Court case. And there actually is no procedure to dissolve a museum. That's why we had to create this statute last year so that some boards could be dissolved, but now we're taking one of the ones that could have been dissolved out of the list. So it's similar. I mean, just a little bit of background. Museums are part of the general county organization in most counties. There is a way to set up a separate district, but that's not what we're talking about today.
So, Mr. Chairman,
Representative Jennings?
so do I understand that once we've created this little critter, there is nothing that might bring it under control or dissolve it?
Representative Jennings, there's nothing in statute that details the process. So if we wanted to take that up, it would be a separate piece of legislation. What we were trying to do with the bill last year and also with this one is to address some of the issues that were raised in that Laramie County case and provide, because there was always an assumption, I believe, that the county commissioners, if they created a board, could dissolve the board. And the Supreme Court didn't think that was accurate. So we made it clear that they can dissolve boards, but we've had a few carve outs. So if you wish to bring legislation to establish some procedures for the dissolution of a museum board, have at it. But most of these, like Representative Craigo said, they're not the same kind of animal as a fair board or some of the other boards. Could you explain that a little more or artfully than I?
Thank you, Mr. Chairman. The counties can create a diverse type of boards. I think the holding of assets and having property is a key distinction. I don't recall off the top of my head what instigated, other than this case, how it was considered, how museum boards got pulled out and it looks very different depending on your county and how counties function. I know the museum operation in our county is very different than probably in Commissioner Short's county. But the holding of assets and the delineation of what happens with those, I think, is probably what was at stake there.
Thank you. Further question? Saying none. Anyone else in Zoom land, any place, anybody wanting to testify? None? Anybody else in the room wishing to testify on House Bill 15? Committee, what's your preference? Thank you, folks. Appreciate you being here this morning. Committee? Representative Chestnut moves the bill. Do we have a second? Second by Nemec. Discussion on the bill. Any proposed amendments? Seeing none. Any comments or discussion on the bill? Question being called. Roll call vote on House Bill 15.
Representative Chestick,
Aye.
Representative Harrelson. Representative Jennings. Representative Nemec,
Aye.
Representative Oakley. Representative Provenza,
Aye.
Representative Rodriguez Williams,
Representative Rodriguez Williams left a vote with me and she voted aye.
and Chairman Washut.
Aye.
We have a total of 7 ayes and 2 noes.
And with that, House Bill 15 has passed House Judiciary Committee, which now takes us to House Bill 96. Representative Craigo.
Thank you, Mr. Chairman, committee members. Thanks for having me today. I bring to you House Bill 96, transfer on death deed insurance coverage. And really what this bill deals with, a few years back, the state legislature created a statute that allowed for transfer on death deeds, which really means I can create a deed, put in there who I want my real property to go to upon my death. And the second I die, that property transfers to the beneficiary, whoever that might be. Usually it's a child. Sometimes it's usually not your spouse, because we have a different way of dealing with that, which is tenancy by the entirety. And that happens within the deed, different language. This would typically be to children or nieces, nephews, or some unrelated person. That happens as well. But what happens is the second you die, property transfers. A few years back, there was a case, I think it was a couple years ago, there was a case out of Minnesota. It became an 8th Circuit federal case. And what happened in that case was a gentleman had essentially gifted his home to his niece through a transfer on death deed. Well, the gentleman dies, property transfers. 3 days later, his ex-wife, who did not get the house, burnt it down. And the niece filed a claim for insurance and was told, you don't have insurance because you do not have an insurable interest. The insurable interest with the insurance died with the decedent. Literally, the coverage disappeared because once he died, the house transferred to his niece, who did not have insurance. And most of us, when your relative has died, the last thing you're thinking about is going to get insurance on the house you just inherited. And sometimes you may not even know, right? I mean, you may find out weeks later that, oh, by the way, my uncle left the house to me in this transfer on death deed. And just to back up a little bit, the transfer on death deed was created by Wyoming to really make it easier for people to take care of their estate planning without having to pay lawyers. I don't know who would want to do that, but pay lawyers lots of money to do their estate planning. This is a simple way to do that. You don't have to have a trust. You don't even have to have a will. You just put in your deed who you want their property to go to.
Mr. Chairman, can I ask him a question?
Representative Jennings.
Thank you, Mr. Chairman. Representative Craigo, so just so that I make sure I understand this. So when the person died, even though their policy was paid up, is that true across the board? I mean, is that the way that works? I mean, it seems like if your policy is paid up, it would be enforced till non-payment.
Representative Craigo.
Mr. Chairman, Representative Jennings. So in this case, it's not true. So let's say, for example, I have a home and I don't have a transfer on death deed. Let's just say I own a home in my, or any type of real property, but I own a home in my own name. I die. Typically, it has to either go through one of two processes, probate, or you happen to have a trust. But in this case, we'll assume I don't have a trust and home is in my name. The insurable interest continues through the estate because my estate still owns the home until it's given to somebody else. But in this case, on a transfer on death deed, there is no connection between the grantor and the grantee. It just happens like that. The second you are pronounced or found dead, the home has transferred to the beneficiaries listed on the transfer on death deed. And so this goes back to a sort of an old common law, I guess, tenet, which is you have to maintain insurance or have insurance in any particular piece of property. You have to have, quote unquote, an insurable interest. And that's what this bill is trying to deal with. And what really happened in this case was there was no insurable interest that transferred to that person. The insurance ceased to exist. By law, they could not insure what was coming after because the person had died. The insurable interest was while he was alive, was with the man. But the second he died, the insurable interest transferred to the niece. But she was not listed as a beneficiary on the policy. And from what I've learned through studying this, most insurance policies won't let you list somebody on a transfer on death deed as an additional insured. And so there was no connection on the insurance policy between those two people. And so hence, ex-wife burns down the house, niece gets nothing. And so really getting back to the bill, the intent of the bill is to create that insurable interest by statute, which we can do. We're subrogating, overriding common law and saying, okay, that insurable interest will hold on for 60 days following the death of the decedent. That gives enough time for the beneficiaries to go acquire the insurance necessary. Also gives them, there's some notice provisions in here that the insurance companies have to comply with, but that's the intent of the bill. That's what it does. It's really to protect people, because this is, I don't think when we created the statute several years ago, I'm sure you were here when it happened. No one thought about this. This wasn't something that came up. And so the insurance, I've talked to some of the representatives from the insurance industry. They're okay with this. I think our state Department of Insurance is ambivalent. I don't think it's my understanding they don't believe it causes any problems. Of course, they're not for or against, and they might show up today to talk to us about it. But that's what we're trying to do, protect the beneficiaries. It's really, as Representative Jennings alluded to, there's coverage should exist already. The only question that the insurance companies have, and it's a valid one, and that's why we're limiting the coverage to only 60 days rather than the entire length of the policy, is there's different risks associated with vacant homes, right? And so the 60 days is similar to what would happen if someone died under normal circumstances without a transfer on death deed. It's a similar time frame of how long it would take to get new insurance up and running for the beneficiaries. And so we're just trying to match that, and at the same time protect those people that have no idea that they probably need protected.
So Representative Craigle, on page 2, line 14 of the bill, it says that not later than 60 days after the transfer of title under subsection A of this section, each grantee beneficiary shall notify the insurer. What's the consequence if they don't? It obviously puts the onus on the beneficiary. And if they don't, then the insurance just goes away. Is that correct?
Mr. Chairman, that's correct. I mean, there's still some responsibility on the person that's inheriting the property. We're just trying to find that appropriate balance, and where we don't have insurance companies holding unknown risk for a very long time, but yet at the same time, we allow the beneficiaries to have time to figure out what they're doing and where they are in the whole legal process.
Question, Representative Chesney?
Yes, Representative Craigo. You said something that confused me. I thought I understood it. Now I think I don't. What I understood when I read it the first time was under the amendments to section 218-103 at the bottom of page 3 and continuing over to page 4. It looked to me like you are basically, and I agree that the common law privity of contract, the owner of the the new owner did not have privy contract with the insurance company. So you're bridging that gap with this and that you're fixing that problem. I agree with that. And I think it's a good fix. But it looks to me like the end 103 says that if the insurance policy would have extended beyond 60 days, it still continues on according to its original terms. So whatever the benefits are under this policy, it continues under its own terms, which I think is appropriate. But that means to me, if the policy was already paid up and would have expired beyond the 60 days, you get whatever that coverage is until it's the expiration of that policy would continue. That's how I read 103. Am I reading that wrong?
Representative Craigle? Is that in accordance with the 26-23-109 language at the bottom?
Yeah, Mr. Chairman, Representative, yes, it refers back. You have to read those two parts
Okay.
in concert.
And what does 109 say? That's okay. So, all right. So that's the new section that's being added. And that's where the 60-day limitation comes in.
Representative Craigle?
Mr. Chairman, that's correct, Representative Chestick. And just so we're clear, the 103, the reason we're putting the reference to the insurance in there is really that's a notice. We wouldn't necessarily have to put that notice provision in the transfer on death deed. But I just reason we're doing that is so if somebody reads that provision, they know to go look in Title 26, the insurance provisions and they have to read them together. And I didn't want to, it gets really long repeating the exact same language in that because the insurance part really needs to be in the insurance code. This is more of a notice saying, hey, lawyers, if you're drafting this and you're doing a transfer on death deed or general public, whoever, read that and then go look at it under 26-23-109.
Mr. Chairman.
Representative Cheston?
So now explain to me again the rationale for limiting it to 60 days. If the policy would have expired, in 9 months from now, why not give the 9 months? Why limit it to 60 days? What's the rationale?
Representative Craigle?
Thank you, Mr. Chairman, Representative Chestick. The idea is and the reason the insurance companies are good with 60 days is because beyond that, we start running into risks, additional risks that they did not sign up for, and that being vacant homes. And so they're a little bit concerned, and I understand their concern that if we start going beyond 60 days, they're absorbing risks that they didn't sign up for because there might not be anybody living in the home. I inherited a home. I already have my own home. I'm not going to move into my uncle's house, but maybe I'll try to rent it or try to sell it, and it might just set vacant. And so that's this, but this also works the other way. If the policy was going to expire right before the person dies, they're going to get the benefit of an additional 60 days of coverage anyways.
Okay. Mr. Chairman,
Cheston?
you anticipated my next question, and that is the reverse situation where the policy would have expired within those 60 days. Or are we okay with forcing the insurance company to continue without an additional premium? They're going to be paying, they're on the hook for some period of time after the policy would have expired until the 60 days are up. They're on the hook. Are they okay with that? And are we okay with that? I mean, I'm no fan of insurance companies, so I don't mind necessarily holding their feet to the fire a little bit longer, but they do have constitutional rights. And is this a taking of that, whatever that premium would have been for those additional days?
Representative Craigle?
Are you sure insurance companies have constitutional rights? No, in all seriousness, one of the amendments that we could all contemplate and we can think about, and I'm always up for improving bills. I mean, if you guys have ideas to make this better, let's do it. I'm not opposed to that. One of the ones I contemplated was actually putting language in there that the insurance companies would be entitled to additional compensation if we run into the circumstance where coverage extends past the termination date of the policy. For example, the person dies 3 days later, the policy expires, and we're saying you have to provide another 57 days beyond that. That's an amendment we can easily put in there. I contemplated it. I'm not sure it's not covered elsewhere, and that's why I didn't do it. And I really haven't had that discussion with the insurance department on whether or not we would need to do that. but it's a thought and it's a good one. And it's one I, figured, it's a discussion I figured we'd have either here or on the floor or somewhere.
Any other questions for Representative Craig?
Yeah, Mr.
Representative
Chairman,
Jennings?
I don't know what that amendment would look like, Representative Crago, but we should probably contemplate that because especially if day 4, the ex-wife burns it to the ground, the insurance company's probably not going to be happy.
Very good. Anyone else in the room wishing to testify on this bill? Any further? Yeah, okay, we got one in the room. Come up, please. State your name and position for the record and then tell us what we need to know.
Mr. Chairman, committee members, my name's Jeff Root. I'm the Commissioner of Insurance. We're neutral on the bill, but I wanted to be here in case there were questions. Having said that we're neutral, after looking at it, we have no concerns with the bill as drafted. We understand there may be an amendment. We've reviewed that too. And we have no concerns with that amendment either. So I'm happy to answer questions if anybody would like.
Question for the commissioner. Staying done. Thank you for coming today. Make yourself available. Do appreciate that. Please state your name and position for the record and tell us what you wish us to know.
Good morning, Mr. Chairman, members of the committee. Catherine Wilkinson here on behalf of American Property Casualty Insurance Association. Mr. Chairman, I will start off the bat with we do have a few proposed amendments just to tighten the bill. We did speak with Representative Crago, and it's still, I don't have any further feedback than when we had spoken last night, but currently in support of the bill, just trying to work to make it better. Mr. Chairman, in all fairness, this is not my strong suit or my wheelhouse, so most of what I'm answering is information that has been given to me by others. So if you have questions that I'm not answering, I will get back to you as soon as I have a correct answer. There are about 20 states that are working on language with this issue that has arisen. So we do stand in support of the bill. We do prefer the 60-day timeline because if it goes much longer than that, it is kind of in violation of basic contract law of the, A and B and C. The third party that's coming in doesn't have a contract with the insured. Without the insured's permission, they can't just assign that contract to someone else. So that is the 60-day. We do understand that there does need to be that coverage of it. Mr. Chairman, I emailed these amendments last night because I was not sure if I was going to be able to make it this morning with the weather, but I could pass that out now. And it's just tightening up the bill a little bit to make sure that that 60-day time frame is in that separate section. So I'd be happy to pass that out if the committee would like to see a paper copy
Please.
of it. Mr. Chairman, I was trying to think if there were any of the other questions that I heard that I have not addressed. But if you would have any questions of me, I would attempt to answer them. And if not, I will get back to you shortly with the answer.
Okay, thank you for being here this morning. Questions for any questions? Give us a moment to digest the amendment. Representative Jennings?
Yeah. Thank you, Mr. Chairman, Ms. Wilkerson. So person's insurance lapses 4 days after death. You guys are okay with carrying that insurance out for 56 more days?
Mr. Chairman, I will need to confirm on that with my client and get back to you. But I think the way that this is written, I mean, I think that is a fairly common, the risk does go up, like they said, with a vacant house. And so I don't know the direct answer on that if a policy were to expire. I understand that they don't want the policy to go to the full extent of whatever the original contract was if it were sooner, but I will check on the expiration of an earlier expiration.
Follow up, Mr. Chairman.
Representative?
Thank you, Mr. Chairman. So scenario number 2 that I'm a little curious about, and maybe the sponsor can answer this one. Maybe this is already covered in other places. So the new beneficiary now goes out on day 5 and purchases another insurance policy, but by statute, we're forcing the original to carry that out for 60 days. I think there's probably already stuff that would cover that, but I just would like to hear it.
Representative Grego, I think you're wanting to chime in.
Thank you, Mr. Chairman, Representative Jennings, and actually, we got a couple of people in the room that know more about it, way more about insurance than I do, but I think there are statutory provisions that deal with that type of situation where you try to go and acquire more insurance than you really need. Most of the contracts also have provisions within them that deal with that explicitly too. First coverage, second coverage, primary, secondary. And so I think that there's probably 2 ways that'll get handled. 1 in statute, 2 in the contracts themselves.
So, Mr. Chairman,
Representative Jennings.
so let's say the beneficiary doesn't know that we're forcing them to go 60 more days without a premium. And they wouldn't know because they wouldn't have found that out. So anyway.
Representative Grego, follow up.
Yes, Mr. Chairman. Thank you. Representative Jennings, I don't think there's any harm in that. I mean, it just means the beneficiary would be insured. And if they weren't paying for the additional coverage under the 60 days because the policy was still in place, no harm to them. Now, they maybe won't get the full refund or something from the estate necessarily wouldn't get the full refund from the previous policy, but that would be the only harm, is that they would be double paying and have essentially can't really have double coverage, but they would be definitely covered twice.
Would you like to chime in?
And Mr. Chairman, I will defer to Representative Grego. Thank you.
Thank you. Further questions? Seeing none, anybody else in the room wishing to testify? House Bill 50 or 96? Nobody on Zoom world? Oh. We have one more question for you. Representative Grego?
Sorry, Mr. Chairman. Sorry. Call you back up here on your amendment
Yes.
on the page 4, line 1. And you wanted the words last titled inserted in there. What's the purpose of that?
Mr. Chairman, give me one moment. Mr. Chairman, I'm not sure if that is for a situation if there's another person that's insured that remains living, or if it's more of a notice. Let me find out and I will get back to you on that.
Thank you. Committee, your preference? Motion by Representative Chestnut, second by Representative Oakley. Amendments, any proposed amendments? Chairman? Representative?
I would like to move the second of the amendments proposed by the Casualty Insurance Association on page 4, line 3. After the end of the sentence, insert for a period of 60 days following the death of the last owner, unless the grantee beneficiary has disclaimed interest in the real property.
Is there a second? Second by Representative Grego. Discussion on the amendment. Seeing none, all in favor of Representative Chestnut's amendment on page 4, line 3, after the end of this sentence, inserting the additional language for a period of up to 60 days following the date of death of the last owner, comma, unless the grantee beneficiary has disclaimed interest in the real property. Debbie, we good on that? Okay. All in favor of the amendment, say aye.
Aye.
Opposed, no. That amendment has passed. Any further amendments? Representative Oakley.
Thank you, Mr. Chair. I think at least discussion, I'm not sure that I at this point have the language for the amendment, but so looking at page 3, line 8, the way this reads, I'm not sure is correct. It says, okay, so stating, the notice basically says stating that the insurance cover for the property will expire unless the beneficiary purchases an insurance policy. But that's not accurate. It's just going to lapse / expire, right, with the 60 days. So in a way, it's kind of nonsensical, right? Like, no, stating that the coverage is going to lapse. And in fact, if they did go by the insurance policy, then it would subsume, kind of like, I guess we discussed with Representative Jennings. But anyway, so I don't think we've got the concept quite right with the wording here.
Of course, there's always the opportunity for a second reading amendment if you want some time to
Well,
draft something.
I think it's significant enough. We need to do something now. Because it's incorrect. The notice isn't to say it's going to lapse unless you buy something. That's not accurate. It's going to expire, lapse in 60 days period. That's the notice.
Representative Craigle, you want to respond to that?
Thank you, Mr. Chairman. I mean, Representative Oakley is not incorrect. The point of the language was to be very clear with the beneficiary that they need to go buy additional coverage if they so desire. I mean, there's no legal requirement to have insurance. If you don't want it, you don't have to have it. And so, I mean, we can change that however the committee desires. It does not hurt my feelings. Let's just get it right. So, but that's the intent of the language, whether it's right or wrong. It's not,
All right, well,
I have no opinion.
Why don't we just pause for a couple of minutes while put our minds onto this drafting of an amendment language, and we'll carry on here in about 5 minutes if need be. Committee is back in order. Representative Oakley, do you have an amendment for us?
Yes, Mr. Speaker, thank you. Thank you, Mr. Chairman. I'm discombobulated. Mr. President. So page 3, lines 8 through 11. So after will, insert the word terminate, and then delete, what? On line 8, and then delete, starting with the word lapse, delete the entire next 3 lines, ending with the word cease, first word on line 11.
So just to make sure I'm clear, on line 8, page 3, after the word will, we insert the word terminate and strike the remainder of that line. We strike all of line 9, all of line 10. Is that correct?
Yes, with the addition of the first word of line 11, cease. Strike that as well.
Also strike cease. Debbie, we got that? You want to read it back to me? Debbie?
So it will read on line 7, starting there, stating that insurance coverage for the property will terminate on the date specified in subsection of this section.
Representative Oakley, is that correct?
Thank you, Mr. Chair. Yes, it is.
All right, I think we've
Thank you.
checked and double checked. We're committee, we all know what we're voting on. Any discussion on the amendment? Representative Jennings.
Mr. Chairman, you're striking subsection B?
No, we would just strike with the word cease at the, on line 11. The rest of line 11 remains.
Okay. Yep, got it.
So we have a motion by Representative Oakley and a second by Representative Harrelson. Any further discussion on the amendment? All those in favor of Representative Oakley's amendment, say aye.
Aye.
Those opposed, no. The amendment has been adopted. Any further amendments to this bill? Any further discussion or comments on the bill? Representative Chestnut.
Yes, Mr. Chairman, thank you. I have, during the discussion and back and forth, I have in my mind resolved my problem with the takings. I think it's okay. And the way it's okay is that it's not without compensation. Because in some cases, the insurance company is gonna, and I think probably in the majority of cases, the insurance company is gonna be a beneficiary. They're gonna get to keep whatever premiums were paid, but they don't have to cover it after 60 days. So they're getting a benefit from it, which compensates them for having to cover it if it lapses during the 60 days. So I have no problem with the takings issue at this point, and I'm in support of the bill.
Thank you. Any further comments, discussion? Roll call, please.
Representative Kriegel?
Aye.
Representative Chestick?
Aye.
Representative Harrelson? Representative Jennings? Representative Nemec?
Aye.
Representative Oakley?
Aye.
Representative Provenza?
Aye.
Representative Rodriguez Williams?
Excused.
And Chairman Washut.
Aye. And Representative
have-
Kriegel, go ahead, please.
Oh, I'm sorry. We have 8 ayes, 0 noes, and 1 excused.
Thank you very much. Representative Kriegel, I assume you'll carry this on the floor.
I would like to. Thank you, Mr. Chairman.
All right. There being no other business before